Okay, we will start. Good morning to participants joining us from the in-person venues and online. My name is Sien Malepo, and I would like to welcome you to our panel on free, prior, and informed consent in theory and practice, and what is the next frontier for struggle. We have 3 speakers today. They will each present for 50 minutes max, followed by 5 minutes pause for translation at the in-person venues. Before we start, just a reminder of a few housekeeping rules. I ask that all online participants please be on mute and keep your cameras off. Also a reminder that we will not be taking live questions from online participants, but please, we encourage you to please post in the chat box. And just to introduce our panel, when we look at the idea or the norm of FPIC, which is free, prior, and informed consent, is a right conferred upon Indigenous communities to give consent for development projects on land they hold rights to, particularly informal rights held under customary tenure. The idea is to establish a bottom-up participation and consultation with Indigenous communities before the inception of development projects, where communities have a right to give consent, including the right to say no. And just an emphasis that it is compulsory under the United Nations Declaration on Rights of Indigenous People of 2007. We do have 3 speakers. I'll introduce the first speaker. So to kickstart the panel, we have input on consent and coercion, communities' capacity to respond to external requests for community land in Liberia, Uganda, and Mozambique by Rachel Knight. Rachel is a lawyer and researcher at the International Institute for Environment and Development. And Rachel worked for many years on community consultations during her time at Namati. Unfortunately, she is unable to join us live due to time difference, and she is a new mom. So we have done a pre-recording with her earlier this week. I'm going to ask the technical people to please play the recording, and then we'll come back after that. Thank you.
Morning. Peoples of the land of our collective fathers.
Sorry, apologies. We're starting with Rachel's recording. The Telanga will come after that. Melody, could you please play the recording?
Hello, good morning. My name is Rachel Knight. I'm an attorney. I work for the International Institute for Environment and Development. I'm also an independent consultant. And I'm going to speak today about work that I did 4 years ago when I was still directing Namati's Community Land Protection Program. So what we had done from 2009 to 2015, we'd worked with over 140 communities in Uganda, Liberia, and Mozambique to help them document their community land rights, draft bylaws for truly participatory, comprehensive local management and governance of natural resources and lands, to delimit and map their lands, to seek titles or registration documents, and to prepare for their community's future prosperity, including to prepare for how they would address any investors who approach seeking lands. And so we did all that work, and which took often up to 2 years in each community. It was intensive and very comprehensive. We were iteratively learning along the way. And I should also say we did this work in Uganda with the Land and Equity Movement in Uganda, which is an organization called LEMU, in Liberia with Sustainable Development Institute, SDI, and in Mozambique with Centro Terra Viva. And so 2 years after we'd finished the work in these communities, we went back and in 2017, we evaluated the impacts of our work in these communities, and we called the leaders and we called the mobilizers and the paralegals, and we said, you know, have you been approached by an investor or the government seeking lands? And if so, what happened? And the central assumption we were testing was that once the communities know their rights and have documented their land claims, they'll act in an empowered way when they're approached by government officials or investors seeking land, and that will result in improved outcomes. And so we called the leaders, we called the paralegals, and we found that of 60 communities, 61 communities, and we found of the 61 communities, 28 or 46% had been approached by external actors seeking land and resources, while 33 or 54% reported they had not. So more or less half had been approached. And of those 28 communities who had been approached, there were 35 separate investment requests. So we asked them about these investment requests. And this is really important, is that 34% of the time it was the government seeking community lands for government projects. 40% of the time it was international investors seeking land and natural resources for tourism, agribusiness, mining, and logging. And 26% of the time it was national or local level elites seeking community lands and resources for investment purposes. And I think this is an important point to make, is because we tend to vilify international investors, but actually they're only 40% of the requests for land, and that often it's the government and its national elites seeking lands as well. And there are, in any given nation, there's far fewer national protections for corrupt land acquisition efforts. There's a lot of international protections and international human rights laws, et cetera, that can support support communities who are dealing with international investors, and you could call shareholders, et cetera. But when it's your own government or when it's national elites, often there's a pretty significant corruption element getting involved, and that's very challenging for villages to deal with. But I digress a little bit. So we asked them, okay, so what happened when the governments or the investors came? And in 57% of the cases, the community just accepted the request. And I'll speak a little bit about what happened. In 11%, the community tried to reject their request, but the investor didn't accept the rejection and pressured or bribed the community to change its mind, or went around the community and just took the land by force. So we're talking about 68% of the communities that gave their land or lost their land to the investor or the government. And then only in 14% of the instances did the community reject the request. And 17%, the community had not yet made a decision. So let's dig into this a little bit. The data suggested overwhelmingly that community land documentation and legal empowerment efforts are not sufficient to balance the power and information asymmetries inherent in interactions between rural communities and investors backed by government officials. And the findings show a clear picture of communities who, even at their most legally empowered, were no match for state power and the threat of violence behind that power, or the challenges of poverty in the face of potential government infrastructure development. There was a community in Uganda, a variety of communities in Uganda, where we had supported these communities to fully protect this vast grazing area for their cattle and their herds, and to clear it of all the conflicts that were on that land, and to help regenerate its ecosystem. And as soon as the government understood that there was this vast area that was actually free, quote unquote, they went in and said, we're going to site a giant hospital here. And the majority of the community said, this is amazing. Thank God. And they didn't even ask any questions. And they gave, I forget how much, I think it was over 200 hectares of land to the government with asking for no compensation whatsoever for a hospital. Now, a hospital probably at maximum might need 10 or 15 hectares. I'm not quite sure why they gave them 200 hectares, but there were a couple of community members who were like, whoa, let's ask some questions. Let's see plans. Let's ask for compensation. And the community members in those communities vehemently silenced those few activists and villagers who were saying, well, let's ask some questions. Let's slow down here. And so there's quite a significant complexity intra-communally when the government is saying, we're going to cite a major infrastructure here that will bring business and potential profits and jobs to your community. So I'm rushing, but I could talk a lot more about that. So in other findings, the stories illustrate how government officials leverage their power and influence to override citizens' land rights in order to claim land owned by villagers for state projects without paying compensation, support bad faith land grabs or dubious consultations for international investors, or provide protection or facilitate land grabs for investments that they or their families or their cohorts or their relatives or their friends have a personal stake in. So after I finished this research, I actually went and wrote a major report on land corruption, which I will provide a link to in my PowerPoint so you can read that. But so much of what we found in this research was that the government officials are overriding citizen land rights and are actually and often the bad actors in the situation. Other findings, these outcomes were prevalent despite community members' articulation that they knew their legal rights and were the same independent of whether or not the community had a formal government-issued document for their land rights, the community had legal ownership under law, or the community fought against the land grab seeking external support from NGOs, lawyers, and political representatives. And one customary leader in Mozambique said, "This experience made us realize that having a certificate is not enough to guarantee your rights, because when the interest is from the state itself, it is difficult to defend because the state uses all the means it has available to achieve what it wants." For example, in Liberia, there was a story of an investor who was actually the wife of a previous president who arrived in Zarke to make a deal to try to just to grab the land for her own investment. And the leaders asked questions. When the leaders asked her questions and asked for more information and called SDI for help, the investor got upset and left. And they heard nothing from her again and for a few months later. And then she returned with the superintendent of the county and the district commissioner, who dissolved the community's existing land and forest management committee, removed the clan chief of his position, and personally appointed a new chief and a new governing body. The investor then returned again with the senator for the region, the superintendent, the land commissioner, and all these high-level leaders from Monrovia, and they pressed the government to sign an MOU ceding the land. And when the youth protested, they wanted SCI to be there and they wanted a lawyer to review the MOU. The senator called in the police, who intimidated them. And then the superintendent so the community still said, "We're not signing anything." Then the superintendent arrived in the community with $30,000 Liberian dollars to bribe leaders. And then they paid the elders to sign the MOU at a secret meeting in a private home at 11 o'clock at night. The MOU did not say how much land or was being given or taken, or offer any benefits. And the community was never given a copy of the MOU. So that is just one of many stories we found that really pointed to significant bad action. I know I'm running out of time. I've got 2 slides left. So of the findings of the 35 external requests for land, only 11 instances did the community make any attempt to refuse the request, ask for benefits, ask for conversation, talk about environmental protections, demand that their rights be respected, ask hard questions, or seek help from government officials and NGOs. And one of the mobilizers said, "You have to be brave to say no, because the investors are accompanied by the government. And if you do not agree, you may suffer retaliation." And I think it's important here to remember that in Liberia and Uganda and Mozambique, within people's lifetimes had been very brutal wars with significant violence. And so to say no, or to stick your neck out and to ask hard questions, when you have experience, particularly the elders, of a state that uses violence and force to intimidate and to take what they want, it's very scary to speak out. And especially in Mozambique, people reported the government didn't actually use outright force. They were just intimidating. And when you have in your recent memory people who are disappeared for asking hard questions, it's FPIC takes on a different kind of tone, because you're afraid to say no to any government official who may have been in some instances, previous warlords or, people who are high up in various armies, et cetera. So a final finding is that of 24 out of the 35 instances where the investor or the government claimed community land, in not even one of those 24 instances did a community get a written MOU or a contract documenting the agreed land transaction. So this is all very, very bleak. And I will finish by very quickly running through some recommendations I have for how to make community consultations and the moment of interaction with investor a little more equitable. I also want to say that when I did this research, it absolutely crushed me as a professional and as a researcher and as a activist and an advocate, because we had spent, many years supporting these communities to know their rights, get titles for their land, become empowered, draft rules for how they're going to manage their lands more sustainably, and get them ready for that moment when the investor came. And it was a significant failure. So it really challenged my assumptions about the power of rights. And I actually left Namati and went back to graduate school and started studying how to support people and cultures to revive their spiritual and emotional connections to land. Because I feel that rights alone and legal empowerment alone is really not enough. It's very, very important for people to feel a spiritual and emotional connection to their land, because that will make them what you love dearly, you fight harder for. And when you see land only as an economic or commodity, it's not always, it's harder to fight for it than when you see it as a spiritual or a cultural or a family, a loved thing in your culture and your family or your community. So I'm not being very articulate because I feel really emotional about this, but so I'll finish with some recommendations, which is that I think it's critical that a radically explicit guide for how FPIC must be done is necessary. What I haven't spoken about is so often among these communities and in my own personal experience, I saw investors come to villages and say, here, sign this attendance sheet, and then use that quote unquote attendance sheet as proof that all these people had signed their approval. Or they would come and say, oh, we're going to bring you so many jobs and so much development. It's going to be so great. But they don't explain, how much they are also how much the investor is profiting for the investment, or what the environmental and ecological and health-based negative impacts will be. And so what we need to be able to hand leaflets to villages to say, here are and also hand leaflets to lawyers and hand leaflets to investors, lawyers to say, this is actually what FPIC looks like step by step. You have to say this, you have to provide this information, you have to show your business plans, you have to show your plan for how much profit you're going to make. You need to make a very, usually SEIA, social and environmental impact assessments are like hundreds or thousands of pages long. It needs to be condensed into a 2 or 3 page thing that is in the local language so people can understand those impacts. So what does free mean? What does free really mean? Like, what does prior really mean? How many meetings are necessary? Is one meeting is not enough? How much time should be given for people to really look at this data? What are all of the different aspects of what informed really means? And what is consent? How do you really prove that consent is a true yes? So, and also a second thing that governments should be doing and advocates should be doing is closing customary acquisition or eminent domain loopholes, because in a lot of countries, even if the community says, no, we don't want this investment, the government can then, or we don't want this, this government infrastructure project, the government can just invoke eminent domain or compulsory acquisition and grab the land by force. A third thing that I think is an important necessary step is establishing national hotlines that allow communities to seek immediate legal advice and support when they're first approached by an outside actor seeking community lands and resources. And then along with that, create a cadre of pro bono lawyers, paralegals, and advocates who can be available to support communities navigating complex interactions with companies and government officials. And these communities should have an advocate's phone number to call or text for immediate help, and that no community investor contract should be considered valid, or no FPIC consent should be considered valid unless it was reviewed and witnessed by an attorney representing the community. A fifth recommendation I would have would be to provide intensive training for government officials at every level of government so that they understand that they are personally impoverishing their people when they push through investment projects that dramatically reduce people's land rights and dispossess them from their ancestral lands. I feel like a lot of government officials don't always see the adverse impacts and physical and emotional and cultural devastation of what it means to sign off on an investor. And I've heard a couple stories of people in certain, I forget which country, but they took government officials to see the palm oil investments that they'd signed off on. And the investors wept because they hadn't quite understood the scale of the destruction that they were personally approving. And I think there's some value there to remember that government officials are human. And then a sixth recommendation would be to sensitize investors themselves to the negative financial impacts of failures to actually get authentic FPIC. There's a lot of data on communities that are not properly consulted or have their land taken through, corrupt means, that they actually they rise up, they use a whole variety of tactics to undermine or stop the investment. And Lou Munden is a researcher who did a report in 2012 on the financial risks of insecure land tenure for investments. And they found that if the investors don't actually go the route, they have anywhere between 10 million and like $40 million in losses caused by communities protesting or stopping their investments. So there's a value in sensitizing investors about the importance of really getting true FPIC. And then finally, I would suggest that those of us as advocates and people who are working on the ground increase the amount of time and energy spent training communities about how to respond to external requests for their lands, how to really demand FPIC, and especially to empower youth because they have less fear of speaking out, and the young people are warriors, and if you really want engines of strong resistance, you have to empower the youth and get them ready to ask the hard questions and to say no and to be the defenders of their community lands. So I think I've gone on too long and I've talked too fast, so I will stop there.
Okay, thank you, Melody. We will now pause for 5 minutes and give the people at the in-person venues 5 minutes for translations. Johannesburg Plenary, if you could please switch your camera on so I could see when you are done with the translations. Thank you.
Dumela magaiso me Rachel Knight ke moeledi ra itsa kere ke motho o tlhalositseng gore ba bile ba dira patlisiso ko dipolekeng tse tshwana ka le bo Uganda, Liberia le Mozambique, me ka 2009 go tla ka 2015 se ba se dirileng ke gore ba tsamaile mo merafeng ba batlisisa merafe ka nna 140 ba batlisisa gore ba bereka bjang ka tsamaiso ya meepo le dipuisano yalo le yalo mme ba feletsa ba dirile di-draft tsa di-bylaws tse le gore ne di le mabapi le di tswa mmung go tsweng foo e be nna gore ba lebeletse taba ya gore ba ba tshwereng ditšhelete ba ba tlo tsenya tšhelete fo ditlhabololo ba ne ba bereka bjang yalo le yalo mme ka 2017 ba bile ba dira evaluation a ke re bagaetso ke go sekaseka le go kopana le baeteledipele ga mmogo le bona di-activist go utlwa gore tsamaiso e ntse ba e dirisa ka mofuta mang mo tlhalositse gore gape go na le dilo tse di bitswang di-land claim yaka rona ka kwano tse e leng gore di dirwa ke puso a re ba dirile metseletsele ya go sekaseka gore batho ka go fapana ba ne ba bua yang yaanong ba ile di-percentage tse e le gore nka se di tlhalose bagaetso ka rona tlhalosa gore 61% ne batla gore go diriwe di-industry ba banne ba batla gore go se go dirwa di-industry mme ba banne ba ganetsa ba banyane ba ba kanang ka 11% ne ba ganetsa gore go se go dirwa skete mme yaanong e be nna gore go fiwa ka 200 hectares ya lefatshe gore go kgone go agiwa sepetlele ko Uganda mme ba bangwe ba botsa mara yaanong ga le tsa lefatshe la rona le fana ka lona mahala le puso gore go agiwe sepetlele rona re fiwa eng or re ungwelwa eng rona ke a ile gore puso e simolola metseletsele ya gore e gatelela batho ba banyane bao ba e leng gore ba bua ka dithata tsa bona go ya ka molaotheo mme a ke re ra ba itse badiredi puso le bona ba na le mathata ke a ile gore ba tsena ka ba kgosa tlhakatlhakano ba gatelela ditokelo tsa batho gore batho se ke ba bua ka ntlha ya gore a ke re anong bona ba itsa gore ke rona ke bona bo gomang ka nna ka gore ba bereka puso le tshwanetse le utlwe ka bona mme ba lebala gore ba berekela rona ka foo mme yaanong ba tlhalosa gore ko bofelong ba bile ba ya ko Mozambique go abetela ko Mozambique batho ba fiwa di-certificate tse di bontshang gore ba na le tetla ya go nna mme di-certificate tseo ga di na dithata tsa gore di sireletse batho ga ba tsena lefatshe leo ke certificate fela ka ntlha gore ke pampiri e senang mosola yaka di-PTO tse re na leng tsona mo rona kwana ke le gore ko mmereko bofelong ntse re na le di-PTO tseo mare re tseelwa ditshwetso ke dikgosi le makgotla yalo le yalo mme ga ba simolola ba ipuelela e nna gore batho ba puso ba dire dipuso ba bitsa maphodisa gore tla le tlo re sireletsang ka ntlha ya gore batho ba bua ke re wa bona so ka mantswe a mangwe gore batho ba tshwana go ipuelela tshwanetse batho ba didimatswe la le gore ba gatelelwa mme ko bofelong o tlhalositse o dikile gore a tlhatlhamole taba ya gore FP ke eng yaanong ka Setswana ba gaetso FP ka ke re ke free prior informed consent yaanong free a ke re o tshwanetse bo o lokologile prior o tshwanetse ke pele a ke re ba gaetso that informed consent ke tumello ka kutlwisiso a ke re wa bona pele o ka fana ka tumello ka kutlwisisano o tshwanetse bo le gore bo lokologile e be le gore o file dipampiri tsotlhe gore o kgone gore o di phuruphutse o kgone utlwa go bua ka eng ka re gantsi a ke re rona re fitlhela ka tsatsi la bofelo ga batho ba fitlha fela fana se ba go fa ditokomane di kwadile ka sekgowa ba go fe tsona ka nako a ke re ba re no tsa ntshwetso fana re kopa re le signemfa a ke re wa bona le ka bona le bagolo ka fa e be batšha bona ba re no a re signeng ka ntlha ba tibisitse ditiro so o tlhalositse gore mathata a leng teng ke gore gantsi batho ba ba sianisang dilo tse dintsinyana ke ba batlang gore ba tla kry-a ditiro and ga re ba lebelela mo community e yotlhe go kry-a batho ba mmalwa ditiro ga go kry-a batho ba botlhe ditiro mme lefatshe lona dile ke a leboga.
Thank you, colleagues. It seems like we are done in all venues. I think one thing I took from Rachel's presentation was the key argument that even legally empowered communities were no match against a determined state or against state power. So now we're going to switch to our next speaker, who is part of Mogalakwena mining communities, or what they call MMC, which is an alliance of multiple community-based organizations affected by mines in Mogalakwena, just outside of Polokwane in Limpopo, in the platinum mine region in Limpopo. So Mogalakwena is part and parcel of South Africa's platinum belt. And our speaker, Mr. Aubrey Langa, he's a community activist and executive member of Mogalakwena mining communities. He'll be talking to us or sharing with us how in their own struggle, they've been leveraging various laws to achieve FPIC for mining projects. I will be sharing screen in a second for his presentation, and he's joining us from the Johannesburg venue. Just 1 second, Mr. Langa.
Hello.
Yes, you can start.
Okay, Tobel. The peoples of our land, the land of our collective ancestors. I greet you, Amandla. In the 15 minutes that I'm given, I will have got to compress the written presentation and as reflected in the PowerPoint that is shown on the screen. The main case here is that our struggle is starting from bottom going up, involving host communities that are directly impacted by mining, especially the host communities of the platinum belt, as mentioned by the presenter there. So I am to make my presentation in Spedi. Non-speaking Spedi participants will follow the presentation. But for their benefit, I'll make the case. The case is about that I'm about to showcase here is that it's an attempt by host communities to achieve a balance of power relations between mining companies and their land rights. So come hona owe re boletse ntharna thoma ka taba ya gore na re thomile re dira eng re šomišitše melao ya mehuta mang ye e leng gore re e berekišitše gore re kgone gore re pushe back towards taba ya go dispossessiwa le go tšeiwa ga dinaga tša rena ke di-mine ba thuša ke mmušo le magoši go ya ka mokgwa re kweleng ka gona beke e ka mokae. Jwalong kudu-kudu re bolela ka molao wa IPILRA o re tla tlogang ka ona o e leng gore go ya ka mokgwa mmamaledi nka ba le mo ke be ke thabile nka ba le gona gore o ba gona mo e leng gore mmamaledi ba re thušitše ba lwele kwa lesetlheng ba fitlhile ko constitutional court mmamotlha re kgona gore re ithekge ka taba ye ba e kry-ileng ko constitutional court gore re tsebe gore go bile le interpretation ya molao o wa section 54. So molao o wa section 54 ke mo e leng gore ge ke tla ka fase ga a slide mo fase ga strategies and practice ya slide sa rena ke mo e leng gore ke bolela ka taba ya molao o gore na molao o thuša jwang. So ka interpretation ya section 54 ntwe e kgolo e re ka e topang mo godimo ga molao o wa section 54 ke gore constitutional court e boletše gore molao o nyaka gore o strike balance gore o thuše gore go be le balance ka mogare ga power between batho ba mine le badudi. Ka mantswe a mangwe go ra gore yona e protecta badudi mara e ba protecte fela ebile e re go ya ka mokgwa re kweleng ka gona ka diboledi tše di tswang ka gona go tshwana le Aninka Classens, Dr. Aninka Classens ba bontšitše mo ke gore ga botsana IPILRA e gata ka ya iphiatla MPRDA. So yeo ke swantse re e thabele ka baka la gore go ra goreng ge ka ntla gore rena re dumele ka setšo sa rena se se dumellang se se recognizang ke IPILRA go ra gore a gone go tshwanetse gore go be le mine mo nageng ya rena. So therefore ke mo e leng gore re re IPILRA e re fa maatla maatla magolo a re a kry-ileng mo ke mo e leng gore re na le critical powers tše di fiwang ke IPILRA ke gore ge re ka re boledišana re na le mine then mine wa bontšha boganka then regional manager o na le maatla a gore a emiše mine go fitlhelela dipolelo tša rena di felelela. So ke mo ke nngwe ya di-critical ke ka mo fase ga section 54 subsection 6 ya molao o wa IPILRA. Jwalong ntho ngwe gape kgolokgolo ke gore re tsebeng gore ge mine o seno thoma go tshwana le ga nnetše maledi o ntsebišitše gore mine o thomile go bereka ke rile ka re go yena ka re ao a se end game a se gore napele le feleletše gane yalo ge le file mine maatla go bereka le ba file consent ka mantswe a mangwe consent eo o ka no e buša nako nngwe le nngwe ka mantswe a mangwe le ka no gana la re o ka re le re gata ka di-consent ra e retriever taba ewe ya di-consent tšewe. So gane yalo ke tla mo parting ya boraro ke šia ke bona ka re presenter kwa le Mmamolepo gore a nšale morago ke tla mo go MMC topic ya MMC section 54 program of action, right? So re ge bomma ke sa bolela ke re be ke sa director presenter gore a kgone gore a tsamaye le nna ka pace. Jwalong ye ke e boletšeng ke re mo re tlwaetše pele gore re a toitoya go ya ka mokgwa go boletšweng ka gona ke nnete re nyaka maatla a e leng gore re thuša ke di-NGO le tla kwa ka mokgwa ke o fang ka gona di-presentation tša gona ya gore le ge e le gore re thomile re le tee ge rena ba mokopane re loša di-mine tše pedi ke di-giant tše pedi ba boletše mo ke gore ka kwa le kudu-kudu ke di-giant gara di-giant tše ke tlabeng ke bolela ka tšona ke Anglo ye e tshwereng mine o leng o mogolo go feta lefase le ka moka so ke a giant e dira di-super profits ka bo di-80 billion rands profit a gone mine go tshwana le wa mohuta owe so ko ona e leng gore is the most profitable mining operation in the world and therefore it's a giant. So re dile di-protest action, re ile ra di-court-o, re ile ra go di-police station, ke dilo tše dintši tše re tlo kwang re bolela ka tšona gore re di dirile mara gane yalo re bone ka re ye re berekelang gare ga tšona ka moka tšekwe ebile taba ya mamaledu ya section 54 ka mokgwa ba re thušitšeng ka gona gore e interprete section 54 jalo re bolela ka programo ya section 54 ye re e dirileng kgatlhanong le di-mine tše tharo ya mathomo ko bolelang ka yona ke ya Ivan Plats, and then ya bobedi ya ba ya Anglo Plat, then ya boraro ya ba Waterberg. Kam ka tše di-mine tše di wela ka fase ga the northern lobe of the Bushveld complex ka mantswe a mang platinum ya go tswa ka Mokopane jalo ge re thoma re bolela ka ya Ivan Plats, se struggle sa rena le bona sa the pushback se thomile ka ge ba nako ba dirang application for mining right. So nako ba dirang application for a mining right re bontšitše gore re na le ditokelo tša rena so ba swantše ba di tlhomphe nako ba dirang application for a mining right ka sekgowa in brief re rile IPILRA must find application in that application for a mining right so they cannot conduct or apply or obtain a mining right without the consent principles under customary law as given effect by IPILRA. So that is our case during the mining right, the mining right application. And this case was taken note by people like Richard Spoor, because about the application of mining right yabona ko Ekolobeni ba lo dia case la ko Ekolobeni ko Pretoria. They had to take our case or by as a case or support a case yabona. Right now, mining right obviously re appeal re IPILRA is a bereka mare e botlhokwa ga nwe ke action on the ground ge ba se ba create license re lwele before ba create license ge ba seno create license a luta continued ya gore ba kitimiše le ge se ba create license now the battleground e bile gore ga nwe le mo the exercise of the mining right gore le create mara le ka se ije le militemo le ka se ije so re lebeletše gore re tlo ba lwešha so ntwe e diregileng ke gore ge ba thoma ba re bona ka go thoma go bereka re ile ra iša lengwalo ko regional manager re thoma process yona ya section 54 then ba re ge regional manager e ignora lengwalo la rena ra pele ra kitimela ko public protector ya ordera regional manager gore e emishe mine ka mogare ga nna ga rena re se re kwane le bona ka fase ga molao o wa IPILRA so ke ka mokgwa e leng goreng section 54 initially ge mine o sa thoma e re bereketše re kgonne gore mine o emishiwe ka nako na ewe then ya re ge e seno re seno go bereka ba mara bona ba re go botswa gore ba eme ba gana go ema ke mo ba ignorile order ela mara go se be le ntwe regional manager e diang ra boela le ko public protector gape le re thušitše batho ba le ba sa tšwela pele ba sa dia boganka ra se kry-e thušo ke ka mokgwa re tsamaileng ra bula di-criminal case against mine ra kitima gape le di-department tše dingwe ra ko department ya land affairs ra re nona ga e ke ya rena le lena re rana under IPILRA ka moka so re protecting evictang batho ba kwe lena le ma department of land affairs ra ba ra kitimela gape le ko SARA le ko mogala kwena le ko di-ministereng ra dia le ka dipili and so on dilo tše ka moka tše ke dirile go pala ra boela gape ra ya ko public protector gane yalo re lata wa ko Pretoria ena Mkhwebane ena ka bo straight ra thoma go dira molato wa maladministration against the department tšeo ka moka tšona so di tlile mona di-DG ka moka tšona be re botše melato against the minister mara ka gore ba protectile di-minister ba protecta di-minister ba re a go tle di-DG fela so go ba le process ya maladministration ye e bileng gona e rile sa re kgotsofatše taba ewe ra nyaka solidarity le di-company tše dingwe including AfriForum so AfriForum ya advocate Kherinele ba re supportile they were in our corner during the time ya struggle sona seo. So a re kgethi re re wa kgonang go re thuša wa re thuša whether ke AfriForum wa keng as long as re pusha struggle le bona. So go tloga mowe ra bona gore aowa go swantse re ketiela nape ra tsamaya ra o tswalela mine re dile la mathomo re dile shutdown ya mine ka December 2018 ra ba tswalela for 7 days ba nyaka interdict against rena nape ra be ra wa re matlafaditse ke Maledu before le ya go court le swantse go baneng le gore ka gore re
Mr. Langa, sorry, you have 5 minutes.
Yo, okay. Yeah. So ka boripana the presentation e re neng le yona e tlo ba re le gore re share le lena ne ntwe e kgolo e re nyakang go e bontsha ke gore di win tse re bileng le tsona ke titime mo go tsona ka under section 54 di win tse re bileng le tsona ga re ga di mines tse tharo tse ka moka tse kwi di ganana le section 54 so di wins e bile gore ke di akaretsa ka dilo tse 3 mo ke boletse ya Ivan Platts fela re kgonne gore ga re ga di mine tsona tse pedi tse di tsa di giant e leng Ivan Platts le Anglo Plat ba ganne gore section 54 ga e apply mo bona because ha ba rate ntwe le ya power balance na pile ra win against bona in argument between rena le bona re mo pela ka regional manager so dilo tse ka obedi tsona ba di busheditse as we speak now Baba directly re tsene into section 54 subsection 3 mediation sessions le bona re khathile di lawyer ke leng go tlo kitima ga re ga yengwa di lawyer re khathileng ke ena Nkaitobi o a re thusheng ka ile ya mathomo ile ko Ivan Platts so yengwe gape gain re bileng le yona ke gore re kgonne go petitiona ga botsana parliament portfolio committee so ga nna tse rena le re emetse date ya gore ba tlatlaneng portfolio committee ya mineral resources e tlhakanela land because ipilra e bolela interpretation of section 54 ka Maledu judgment ere nako nngwe le nngwe MPRDA e swantse gore e tsamaye le ipilra so ke ka mgo e leng gore re gain ka gona so re nyaka gore batho ba gesho le bona ba kgona go tseba gore na ge ba ilo ba dia pushback ba lwe ka eng le ntsha marumo ka moka a re lwe ka le rumo le tere go ya ka mokgoba re empower leng ka gona ka di slide go tswa le se se dileng ke papa Ben cousin mo e leng gore ba re bontsha gore ke rena e tshwantse tloge mo rena a ra tshwanela go tlogela ntwarna mara obviously ka se bereke re le tere re le in isolation amandla.
Okay, thank you, Tetelanga. This was unplanned. I was not aware that you're going to present in Kasepedi. So I would just ask the two venues in East London and Devon to please mute us so that they don't hear us and then they can do the translations. Mr. Langa, I would like to invite you back to stage so that you could summarize. I know you're a good English speaker in English for our online participants in 5 minutes. If you could just summarize to them how the community uses IPILRA and Section 54 of the MPRDA to literally fight for the implementation of FPIC, please. Thank you.
Thank you for the opportunity to summarize this in English, and it is important. What we are basically saying, we had to rely on move away from the traditional strategies that we used, including protest action, opening criminal cases, and so on. But after 2018, October, the Maledu judgment, we had to rely on Section 54, which empowered us in the sense that it stated that IPILRA must always be read. MPRDA must always be read with IPILRA. But going further, that the IPILRA, in fact, is because it is protectionist, then it means that IPILRA, in fact, does trump MPRDA. It is not the old, which means it's turned over or the turn the tables over. Previously, the mining companies used to say that the MPRDA trumps IPILRA, and that is what the mining companies like Anglo-Plat or Ivan-Plats told us during the application for a mining right, that the MPRDA trumps IPILRA. So we are now empowered to say, no, without any IPILRA, there is not going to be any mining. But it also gives us strength and confidence in the appeal that we submitted against the mining right, because it now says that without IPILRA, the mining right ought not to have been granted in both in respect of the project in Mokopane, Ivan-Plats, and the project in the Waterberg district. And as far as expansion projects are concerned, especially the expansion project whereby Anglo wants to relocate 1,000 households of Luruleng and Skimming. That matter is also under the Section 54, and we are calling upon civil society to assist us in this battle of the pushback, whereby Anglo is now implementing the process of relocation of the community without taking into consideration IPILRA. So that will be my summary. Thank you.
Okay, thank you. It looks like our venues are done with translation. I will now introduce our last speaker, who will be looking at FPIC and natural resources with particular emphasis on the West African experience, lessons from Nigeria. Professor Dayo Ayoade, a professor of energy and natural resources law at the Faculty of Law at the University of Lagos in Nigeria. Professor, you may share your screen.
Good morning, ladies and gentlemen. It's a pleasure to be here. And my thanks to the organizers, in particular, CN Molepo, as well as a very good morning to the community groups that are attending the conference.
Professor, could you, wonderful, thank you.
Now, and here's my topic. I'm looking at FPIC or FPIC and natural resources, and just looking at some of the problems that we've had in Nigeria, which I hope will be of some interest to the group. My work looking at just the introduction, stakeholders, and some of the matters I'll be considering. I told that about 15 to 20 minutes. So when we talk about FPIC, the right to FPIC, it's basically based on people's rights to their own lands, to natural resources, and also self-determination. FPIC, of course, comes derived from international law, and I'll talk briefly about some of the international law later. And it rests basically on those rights of participation. Should communities be consulted? Do they have indigenous property rights? We assume this, and on this basis, FPIC rests. It also kind of ensures that when we talk about communities, or host communities as we refer to them in Nigeria, that they're not intimidated or forced into allowing development or resource extraction within their territories. In this paper, I'll basically be talking essentially about the oil industry in Nigeria. We do have a mining sector, or mineral sector as we call them, solid minerals, and we also have about 40 different minerals. However, the mining sector in Nigeria is not organized or as that in South Africa. It's mostly artisanal mining. We have a lot of problems with illegal mining. And when you have illegal mining, there's no way you can go to those type of companies. Well, they're not companies really, legal miners, and then for the communities to engage with them. So that's not an issue. So we just focus here on the experience within the oil and gas sector. And basically in Nigeria, what we find is that there has been a big struggle over natural resources between the government and the communities, who of course live on the lands and waters that were severely degraded by oil and gas extraction. Now, some of the stakeholders we're looking at, the federal government of Nigeria, of course, is the biggest stakeholder because it controls the country. Although we have a federal system, we have federal government, we have a state government, we also have local governments, but the federal government takes a lead role when it comes to natural resources in the country. We have international oil companies, some of the names you may know, Shell, ExxonMobil, ENI, and so forth. And also we have indigenous oil companies. Those are companies, Nigerian companies that actually extract and produce oil and gas. We have the NNPC, which is the Nigerian National Oil Company Limited, that's recently been given a status of a private company, but is still owned by the federal government. So, and then we have what we call host oil communities, or also indigenous people. That's also a bit problematic because in Nigeria, all groups or all ethnic groups essentially are indigenous in one way or the other. So if we look at the kind of elements that make up FPIC, when we say a free, when we talk about free, because we're talking about free prior informed consent, when we're talking about free, what does free actually mean? And that sometimes can be very problematic. How do you know that the approval granted by the community is voluntary? Also free of intimidation, free of bribery or manipulation. We should not forget that when we're talking about some of these powerful stakeholders, they have a lot of money. There's an imbalance in the relationship between the parties, and it's quite easy for these powerful entities to manipulate, bribe, or intimidate members of the community. So that's always going to be an issue. Also, trial. There will be no point getting the permission of a community after work commences on the land, or the land is being dug up, or exploration has started. So permission must be obtained before any authorization or commencement of an activity, and that can be quite problematic. When you talk about informed, it's a question of what the community should have access to. Does the community have access to proper data? Do they have access to objective information? Do they understand the implications of accepting that development? So that's what we call informed decision making. Because if they understood the implications, then you would say the community was properly informed. But if there's any difficulty about accessing information, maybe you have scientific documents running to hundreds of pages. These communities are not so well educated. There's no way they would be able to make an informed decision. So what about consent? Consent also can be problematic. When you talk about consent under FPIC, we're talking about collective decision making. And this has to do with customary, which are quite informal processes within those impacted communities. Those processes can differ, especially in Nigeria, from community to community. Nigeria has about 500 languages and different ethnic groups in different areas, different customs. And each of them have their own unique mechanisms and ways of coming to decision making. And that can be problematic. So when we're talking about FPIC, there's no single internationally agreed definition, and that, of course, can be problematic, but it's well recognized. You have the UN Declaration on Rights of Indigenous People, UNDRIP 2007, the International Labour Organization Convention as well, 169 and other conventions as well, they actually recognized what it is. But it's also difficult because there are different stakeholders give it different weights. And is it a right? Do they have a right? Do indigenous people have a right in terms of a legal right? Is it a derivative right? Is it a concept? Is it a principle? What is it? Because we have so much uncertainty, that provides a problem. But whatever we consider the uncertainty, there is consensus that all states should respect and protect the rights of indigenous communities. However, because of this uncertainty, governments have considerable discretion in how they formulate or implement it. Now, if you look at UNDRIP, Article 32 deals with what specifically with natural resources. It says something like indigenous peoples have a right to determine and develop their own priorities and strategies on how they use their lands or territories and other resources. That's very clear. The states shall, it must, has no choice in this, consult indigenous people. That means indigenous peoples have their own representative institutions and they must obtain their free and informed consent before the approval of any minerals or resources projects. Also, the states should provide effective mechanisms and the kind of measures that shall be taken to mitigate environmental, economic, social, cultural, and spiritual impacts. I mean, you can see it's quite broad. It's not just the physical, but also the spiritual. When we look at the oil sector, the environmental issues are very important. The economic issues are, of course, there, and social, cultural issues are also quite important. Now, when we look at how FPIC and natural resources interrelate in Nigeria, that's where some of the problems start. The country is essentially dependent on oil and gas revenues. And when the country is so dependent on oil and gas revenues for over 90% of its foreign earnings, it gives that natural resources sector an undue and enhanced status within the country. And also, if we're looking at the rights of states, the rights of governments, FPIC that looks at and tries to empower the indigenous communities and those communities and host communities that actually live on the lands and in the waters where those resources are, now conflicts with the permanent sovereignty of natural resources, which is a concept of international law, which is also very, very, it's actually almost, it's customary international law effectively, because most states everywhere in the world now recognizes that a country has sovereignty over its own natural resources and how it develops those resources and utilizes the process of those resources for its own people. Now, if you go to the Nigerian Constitution is very clear. Section 44.3 says very simply that the federal government of Nigeria owns all the natural resources in the country. So whether it's minerals, whether it's oil and gas, whatever it is, the federal government owns it all. And you now find a situation where those international companies, as well as the Nigerian companies, are of course legally only obliged to obey national laws. They obey the law of the land, and they're not, of course, governed by customary law or customary rules. And it has caused a situation where host communities have been ignored and they've suffered from devastating ecological degradation, a lot of oil spills, gas flaring, and so-called acid rain. And the problem where we don't accept the importance of host communities is that the laws will only be theoretical in a way, because the rebellion on the part of indigenous peoples can become a problem. And we've seen that in the oil and gas industry in Nigeria, and it's been something that has affected the national unity, has affected the country in many ways, foreign perceptions about the country. When we're talking about communal conflicts, we're talking about violence, we're talking about oil theft, kidnapping of oil workers, shutting down of oil mining sites, and so forth. All of that, of course, is resulting in significant economic loss. So there's no benefits for companies to ignore the important stakeholders of the indigenous communities. And just a visual representation there of what the community has to live with. That's crude oil, of course. These lands have been significantly damaged, perhaps even maybe repairably so. These are communities that live on the land. They live on fishing. They are fishermen, they are farmers, they live basically, they have spiritual attachments to the land. All they do have one connection or the other with the land. They have to drink that water. They have to utilize that water for household purposes because of lack of development. It's quite clear that it's impossible for communities to live in this manner.
Professor, you have 3 minutes left. Please do wrap up. Yes.
Well, these are some of the laws that we have in Nigeria, and these laws are very important. I've talked about the Constitution. Nigeria has all these laws. The latest one, the Petroleum Industry Act of 2021, allows it's a new law that basically transforms the entirety of the law that regulates the entire oil and gas sector. But what you find is that despite the fact that it deals with host communities, all it does is to help host communities to get not to get compensation or to remediate the oil and gas spillage. What it does is to say we'll help you have funding for development, but to actually consult the communities, no, we don't have a lot of laws on that. FPAIC is essentially missing from all these laws you find, and all these laws are also reflected in many government institutions. So there's a big gap in Nigeria in terms of FPIC, and that's very problematic. FPIC can be problematic. One thing that we're finding right now in 2022 August, we have communities that are rebelling against the sale, the proposed sale of a $1.3 billion asset sales between international oil company ExxonMobil and indigenous company Seplat Energy. The community says that cannot happen, demanding environmental, socio-economic audits and remediation of the oil contamination of their waters and their lands. Now, how would this happen? If the community had been engaged and there's been a robust engagement from the beginning, this wouldn't have been a problem. So basically, Nigeria's government too needs to establish a specific regime for FPIC. What I can say is very difficult politically to grant oil communities any power to approve or suspend petroleum projects. That will not work in a complicated country like Nigeria. But that said, we can have robust consultation. We can have community engagement. We can have the communities being empowered to take part in decision making, and that's what is quite missing in Nigeria at the moment. So to conclude, FPIC is a very important international concept. No government can ignore it. All the stakeholders in the natural resources sector have to bear it in mind, because at the end of the day, they will lose a lot of money if the community is not engaged and if the community does not consent to that development. So it'd be a waste of money on their part. And this requires the Nigerian government and all governments really to carefully design and put in place an appropriate FPIC or community engagement regime. And I think every country will have to decide what is appropriate for it. It has to do with your legal tradition and the way the constitution and how things work within those countries. And also we can find that FPIC can result in significant economic or project risk, as well as economic loss, as our Niger Delta experience from Nigeria shows. But I would like to end on an optimistic note and say we need genuine change, and governments have to be encouraged through academia, community activists, and the indigenous community working together to give a robust voice to these communities, because it's in the interest of everybody to do so. Thank you all very much.
Thank you, Professor. I think there was a statement from one of our community delegates in Devon yesterday that he realized that was after the panel of African comparative experiences on formalization. And he said he realized that in Africa, we have the same problem, same struggle. And I think, as you've said, a big gap in Nigeria is a gap to directly address FPIC in terms of laws. In South Africa, we have IPILRA, as the previous speaker has mentioned, which is an interim law that protects those informal rights and enforces, or is what this community is using to enforce FPIC. And I think it's just a call out to South Africans to say, we need to protect this law. We cannot afford to have IPILRA to be dissolved. With that said, I'll just switch over to the venues for 5 minutes for translations. And Professor, if you could stop sharing your screen, and then we'll come back after 5 minutes for questions. Thank you.
Okay, especially ke Professor Dayo of Nigeria. Okay, Kaburipana uba agatella tabela ya FPIC, free in prior and informed consent gore. Go tlo ba le tšwelo pele mo ga borena. Arebe batho ba ileng gore re tsebile pele ga nako ra ba le ditokomane ka moka goba ditaba ka moka tša wela le tlhabologo yeo gore ge re tla go tšea sephetho sa gore re a dumela goba ga re dumele e be le gore re se tšea re na le ditaba tše e le gore di swanetše mo e leng gore o bontšitše gore yona principle ya FPIC e tšwa go melao ya boditšhabatšhaba a se nto e leng gore motho o di o tsogare ma motho a re tshwanetse go latela ye ene ba re e kgontiša gore ditšhaba tše e leng gore ke beng gae ba di-investment ba kgona go tšea karolo ga go tšeng diphetho tša gore tlhabologo yeo e be gona goba e se be gona na mara o re se a se boneng kwa Nigeria ke gore gantši go ba le kgotlhano gare ga ditšhaba le mmušo mabapi le tšona ditlhabologo tše di diragalang ka gore gantši ko melaong ye e leng gona ko Nigeria ga e a tsentšha yona tshepedišo yela ya FPIC molawana ola wa FPIC a ba o tšeela godimo kudu ka gore melao ye e beng gona ka moka na yona is like le batho ge ba e dira le batho ga ba tšea karolo mo e leng gore e fetša e dia gore go be le ditlamorago tše e leng gore ga di kgatlhiše ka gore a ke re lentšu la ditšhaba ga se le tšeelo godimo ge ba se ba le tšeele šedi go ra gore go fetša go e ba le dikgotlhano gare ga mmušo le ditšhaba and ebile go ba le ditlamorago tša tlhago tše e le gore ga se tše di botse o kry-a le gore di-oil tšela ge dintše di elela di dirang di senya le diphedi tše dingwe gona moo and-e go batho ba e leng gore ba kgatlhanong le tšona ditlhabologo tšeue ba na le go ba itia ba ba kidnapper a kere mara taba ya Nigeria ya kidnapping le ya ikwa kere that is why le šetše le tšhoša batho le rena di Boko Haram a le tsebe Boko Haram ya Nigeria tše dingwe ba di tswalela ditlhabologo and then le gore ditšhaba di tšeela maatla matsogong a bona that is why ba re ditlhabologo tše dintšhi goba di-investment tše dintšhi di no fela di feleletša e le merusu goba dintwa mo e leng gore kgoeletšo ke gore wona mmušo a o bone gore o tsentšha batho ka go tšeeng diphetho ka gore ba fetole melao ya bona e akaretše lentšu la ditšhaba ka gare ga yona melagwana ye e leng gore e laola tshepedišo ge re tla go tlhabologa ga lefase I think e felela gona moo nka se thoke bolelo tše dintši le ya di tseba ke re lanka o le boditše mos nna se nna moruti wa tšona amen.
Okay. Greetings, everyone. My name is Francina Nkosi, and I'm based in the rural area of Lephalale under organization WOW. Concerning free, prior, and informed consent, I'm not going to ask a question, but I'm going to do a comment. As mining affected communities or people who are in the rural areas, we need to be united to make sure that we promote the free, prior, and informed consent. By resisting, we'll be
We
making
have
sure that
13 minutes left
the
before we have to
government-
all quickly rush into the closing plenary. Can we take 2 questions in Devon if they are ready, and then we'll take 2 questions in Johannesburg. Devon, are we ready for questions? Okay, while you're still getting organized, I'll go to Johannesburg. I thought I saw people in front. Joburg, please, quick inputs.
Okay, thank you. My name is Francina Ngosi, based in the rural area of Lephalale. I'm gonna comment and also ask a question. My comment is, as mining affected communities or people who are in the rural area, we need to unite and form a solidarity of resisting to make sure that these mega projects, they understand the importance of informing communities prior and also getting our consent to continue with the project. My question is, when women are being killed, what can we do? Because women are the ones who are resisting more, because they are protecting their indigenous seeds, plants, and also their culture to make sure that they preserve for the future generation. Thank you.
Dumelang bagolo, koketso manko gape mo. I think in all the sessions they've emphasized the point of how land is important to African spirituality. And then Ms. Knight has made a presentation along those lines. So I would like to make a comment that it would have been interesting, since everyone is mentioning a spiritual disconnection in terms of removals from ancestral land and everything. It would have been interesting to have the voice of traditional healers in the house so they can at least align our debate along that discussion. Thank you.
Thanks very much. Billy Masha again from Johannesburg. I want to check with this free, prior, informed consent, because it's new relatively to some of us. Is it possible that in a case where there's never been such, there can be a recourse? In a case where communities have been involved or signed or manipulated to sign such deals, can there be a recourse for such, to say that we were never informed fully well before that? Thank you.
But when you medicine, that kikopa cheka ka case ya lona le Anglo, right? A situation where you find that such cases are referred to as civil cases, and dinka about 3 to 4 years. Court. Now, what happens in the interim period? An order airing, the man should do nothing, you should do nothing.
Okay, we'll come back for the answers. I'll just quickly go to Joburg to take to Devon to take 2 questions. And Mr. Langa, you can approach the stage in the meantime while we get the 2 questions from Devon.
Devon is ready.
Okay, thank you so much. Mine is not even a question, it's just a comment in terms of free and prior informed consent. Honestly, this thing, forget about that. It's a word of English. This is the thing that we know for quite a long time ago, but it just disappeared because our communities, they just move a little bit of being attached with land. That is why people, they forget easily. And I agree also with the speaker says that in order to fight for FPIC, you need to be brave because you're going to face with brutality and all sorts of violence. Now, I've experienced that in our community because we never even think of this such a thing, but we just organize ourselves as community of Kolobeni to say no to mining. because of we attached with the land. And we don't see a land as a commodity. We don't see a land that is something that you can sell. But if our communities, they just shift from that being attached with land, it's easily to be not to understand the FPIC. Thank you.
Thank you. My apologies, East London. I was not aware. Please, oh, sorry, quickly, Devin, one more question, then we switch to East London.
Okay, my name is Nongbonga. I'm in that point of a bribery. The bribery is in the grassroots level, and we are not all of people who are the leaders or stakeholders getting the bribery, or all of the community getting the bribery. It's the only stakeholders and the leaders who lead the community getting the bribery. So we as the community, we must make sure that if we get to know something like that, we must face with the leaders in the community.
Thank you so much. East London, quickly, please. Let's keep the questions brief. We are running out of time.
All right. Oh, no, thank you. Thank you very much. I think one, I'll be very short. One, while I was caught by the presentations that were taking place here, because currently there's a water bulk infrastructure in my community that is taking place. And you know what happened actually was that the contractor destroyed the defenses of the people as they were trying to make trenches. Yeah. So what actually happened was that now the community was complaining to the headman, and the constructor said to the community by the time they were destroying the defenses that they are going to be fixed, and also they have spoken to headman, only to find out when they went to the headman, there was no such consultation. And those people that were complaining, of those families, the project manager said that he's promising them jobs to be part of the project. By that, he's trying to say that he's trying to bribe them so that they cannot talk anymore. And he said that he's going to fix that. Yeah. So there's a lot that is taking place, by the way, and this destroyed also some field crops, because there are also livestock that lives in those in those fields. Yeah. So as they were fenced. So this is very important to me, and I think maybe going forward, I'm going to relate these lessons to the community, and will take up further actions. Thank you.
Okay, thank you. East London. Okay, can we switch to Joburg? We'll have Mr. Aubrey answer the first two questions, and then we'll go back to Professor Dayo to give his final remark. Okay, East London, your hand is up.
Yes, just one question. Okay, maybe as a follow-up to what my comrade has been saying here. In a case whereby communities realize that FPIC has not been implemented when the project has to start, or wherever the project has started, is it possible for communities to reverse, whatever, for instance, in this case, to reverse the project and maybe get people that have their assets being destroyed, having been throughout the implementation of the project? Can those people get, some kind of what do I say it? But can people get paid for whatever has been destroyed? But my question is, if there was no FPIC elements implemented throughout the project, can people have, maybe through IPILRA, or can they be able to reverse the project and have, some kind of a payment or whatever?
Okay. Thank you, East London. I'm sorry, I have to cut it short. Mr. Langa in Joburg, can we please have your camera on? Please, I think you have a similar question from East London and Mr. Billy about the possibility of reversing FPIC, or if FPIC did not take place when a project started, what is the possibility of reversing such a project using FPIC? Thank you.
Yeah, let me start with this second question. Yes, the question is yes, that IPILRA, consent granted under IPILRA or under FPIC, it can be retrieved. So it is not a once-off or once-for-all consent. That consent can be withdrawn or it can be revoked. That's a proper way to use. So once the project is ongoing and the people get together and say that they did not want the project to proceed, and therefore they can have that project stopped by having reviewed or retrieved or retrieved the consent. That's question number one. The other question is whether while the mining or whether a mining project that is ongoing can be stopped during because IPILRA or Section 54 is invoked. The question is also yes, that the mining, according to the interpretation of Section 54 by the Constitutional Court in Maledi judgment, they say that they find it difficult to can see how a mining company could go ahead and mine after a IPILRA has been initiated. So once it is initiated, everything must stop pending the finalization of the IPILRA project. In fact, as far as litigation is concerned, that you have mentioned, the Constitutional Court says a mine is not entitled to take the community to court once IPILRA is invoked or triggered. So they are not able to, there should not be a long, the community should not be subjected to a long period of litigation period that you have mentioned, because there should not be any litigation in the first place once IPILRA is initiated. Thank you.
Thank you, Mr. Langa. I think the people in East London, they can get in touch with you through the ARD. And I'll just quickly give Professor Dayo 1 minute to do final remarks, and then we'll have to leave the room. Thank you.
Thank you very much, Sien. It's a pleasure to be here. I can see that South African law is actually is an advance of what we have in Nigeria. I'll be proposing here in Nigeria to learn from South Africa for us to get in the rights of a community to withdraw consent for projects. Thank you all very much.
Thank you very much to all our speakers, the participants. It was a very insightful and moving session. So now we will be going back to the main plenary room. You can just see, you'll see at the bottom of your screen on your right, a blue button with leave room. Then you can click on that and we'll meet in the plenary. Thank you so much, everyone. Bye.